Welcome everyone. Thank you for joining us this morning. I'm Nikki Jovicic from LookUpStrata, and for this Queensland Q&A webinar session, I'm very happy to welcome Michael Kleinschmidt from Stratum Legal. Today we're talking about solar in Queensland strata properties. Michael has a presentation and then we'll have a few questions to address. Please stay with us until the end of the session for an update on Queensland legislative reform to watch out for in the near future. Feel free to share this recording with your neighbours, committee members, other staff members, or anyone you think will be interested in the information. Before we begin, I'd like to mention that the information contained in this session, including the discussions that arise from submitted questions, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in this session. I'm delighted to introduce our panellists today, Michael Kleinschmidt from Stratum Legal. Michael is a legal practitioner director of Stratum Legal, a specialist strata law firm on the Sunshine Coast. Michael practices in all areas of strata law for every type of stakeholder across Queensland. Michael is a fellow and council member of the Australian College of Strata Lawyers. Michael is a regular contributor to LookUpStrata. He submitted an article back in October 2020 titled "Permissions for Installing Solar Panels in Strata." That article has had over 6,000 page views and multiple shares, questions and comments. And the interest in this article of Michael's is the reason for the webinar today. I'm very excited to get into this topic. I'll leave you to carry out the presentations and I'll join you a little later in the session to cover the Q&As. Welcome, Michael.
Welcome, everybody. I usually do love actually getting to see you all in person, so because it energizes me. So hopefully I can still provide that energy for you today on this topic. Look, it's for me a very interesting topic because it crosses across a number of interesting areas of the law. It's something where good policy settings tend to have a really practical impact upon real world problems. You know, Australia's got one of the highest rates of solar take up in the world, and we're actually now starting to get some problems arising from that in terms of the amount of energy going back onto the grid. But in any event, my approach today, what I'm going to try and do is to take a practical, what I call a practical legal approach, which is to take you through the process, to talk about some considerations and also the major provisions of the legislation. I'm not going to be sitting here quoting sections, chapter and verse. Where possible, I'll just summarise them for you, but I will tell you which sections to go and look at, because I know that that enables people to do a bit of study at home later on. Now, hot off the press, literally an hour and a half ago, is 3 flowcharts which I've prepared. Now, for the flowchart purists out there, I have done my best to use the proper circles and boxes and diamonds. So by all means, give me some feedback if you like. In fact, I do welcome that. And obviously, I'm happy for you to reproduce my flowcharts when you come back. Just please acknowledge their original source. And if I get some good, really good feedback, I'm happy to incorporate changes as well. Now, bear in mind, what I've done and what I've prepared for is Queensland only. So if you are from one of the other states and territories, I'm sorry, but I won't be able to help you. Stick to your knitting is my rule, and Queensland is my area of expertise. When I talk about the Act, I'll be talking about the Body Corporate Committee Management Act, unless I otherwise specify, and I'll also be talking about the standard module, of which we have a new version this year. So what I'm going to do now is just share you into the first flowchart. I have 3, and we'll be going through them flowchart by flowchart, the idea being to take you through the process and then also talk about those provisions. So there's 3 flowcharts we're going to talk to. The first is what I call body corporate installation. So this is a situation where the body corporate wants to go and get a solar system, and typically body corporate's going to source it, going to buy it, going to install it. The electricity is going to be used for the common property. It may be sent back to the grid. It might be able to be used by the owners, whether or not through a battery and some smart billing, or on a first in, first served basis. So this is really a body corporate initiated process. So just to give you a quick overview there, this is what the whole thing looks like. and we're going to go from beginning to end, and I'll take you through each one of the steps. As Nikki said, we'll get all 3 flowcharts to you at the end, later today. So, body corporate. Someone on the committee says, let's get solar on the roof. We've got a great big area of roof there. Why don't we get some solar PV cells and defray our common property electricity costs? That's not an unusual thing for me to hear from committees and from bodies corporate. And typically I'll get involved anywhere from that very beginning through to, we've just tried to pass a motion and it got voted down. What do we do? So this is the way I approach this process, and it's the way I recommend that you approach it. The starting point is to get yourself the survey plans for the community title scheme and the currently recorded community management statement. And I mean all of the survey plans and the currently recorded CMS. Because the first and most fundamental question is, where are we going to put it? And that, of course, dictates what happens. So this leads us into our first sort of couple of decisions that we have to make. And that first decision of where. So once you've got the survey plans and the CMS, the survey plans will give you the definition of the lots and the definition of the common property. The CMS will also give you the areas of exclusive use, and that's really important for reasons which will become apparent as we move through. So let's say, and just on a practical point, when we're talking about a solar system, it's not just the cells on the roof. It's not just those PV photovoltaic cells on the roof. There's cabling. There's obviously the control systems. There's the inverter. More and more, you'll see batteries. There'll be meters, all sorts of things. And what that means practically is that you are having to map out where that other stuff goes. But obviously, it's somewhat like sails on a sailing ship. The thing that's most obvious is the canvas. And so that's the PV cells. Whereas all the ropes and the pulleys and all the rest of it go with it, you do have to work out where those are going to go as well. But you start with where. Now, the first thing I'll hit in terms of where is, if this is a body corporate and part of your system, you think you need to put it on the lot as opposed to the common property. And we might take something that's really innocuous, like wires and cables. Well, there is actually a capacity for the body corporate to put part of a solar PV system inside someone's lot. And the reason for that is that we have easements in favour of the common property for utility services and utility infrastructure under the BCCM Act and the Land Title Act. In particular, they're under Division 5, Part 6A in the Land Act. And that division applies to building format plans. So building format plans, remember, they define lots by a building with boundaries, centre of the floor, centre of the ceiling, centre of the walls. Volumetric format plans, which is points in space, and standard format plans, which is points on the ground. So those easements apply if you're under those three survey plan types, but with respect to standard format plans, only if your lot was created after the 13th of July, 1997. So in those statutory easements, there is an easement for utility services and utility infrastructure, which is in section 115, capital P. And what that section says is that an easement exists in favour of the common property and against the lots for supplying utility services to the common property and establishing and maintaining utility infrastructure reasonably necessary for supplying utility services to the common property. So utility services are electricity. Utility infrastructure are the things, the physical things that you use to move the electricity around or to create it or to store it or to export it or to measure it. So that easement right means that a body corporate actually has an easement over a lot for the purposes of utility infrastructure for supplying utility services. It comes with a catch, and the catch is that the exercise of rights by the body corporate under that easement must not interfere unreasonably with the use or enjoyment of the lots against which the easement lies. And that's that first diamond in our in our example there. So if you're looking at putting part of your system into a lot, like a cable, if it unreasonably interferes with the use and enjoyment of that lot, you can't do it. A pipe or a cable often will not, whereas waltzing onto someone's standard format plan lot using all of their roof space for an 18 kilowatt solar PV array is probably going to be an unreasonable interference, okay? If you interfere unreasonably, go back to where am I going to put this? All right, so we're back to the where. So we've now covered the lot. Most of the time with these sort of body corporate installations, we're looking at the PV cells being on a common property roof, okay? And so we're down into the common property and we're saying, well, this is where most of it is going to go. From time to time, when you're having a look at these systems, it may be necessary to put stuff into someone's exclusive use area. A classic example is the inverter or inverters having to be located in a basement area next to the electricity meters or metering equipment, and it just happens to be in somebody's car park, which is an exclusive use area. Now, this is problematic because there's a little bit of a quirk of the legislation, and there is a limitation. Practically, there's a limitation because once you install this stuff, it's a body corporate asset. You install it, it becomes part of the common property. And there's a fundamental limitation in Section 177 of the Body Corporate Community Management Act that says that you can't grant exclusive use. So you can't have exclusive use over utility infrastructure, which is common property. So if a body corporate grabs that inverter or those meters, puts it into someone's car parking space, it becomes a fixture, it's contained in the exclusive use area, and that's prohibited. Perhaps more fundamental though, of course, is this issue of, do I have an easement right to go and put it there? And the answer to that is no, because again, there's a little loophole in those easement provisions in the Land Titles Act. You can have easements in favour of the common property against the lots, which is the one that we used before over here. But when you're trying to get an easement in favour of the common property against exclusive use, there's no easement right in favour of common property against common property, because exclusive use is common property. So it's a little loophole that I'm going to recommend that the government fixes, because I've seen that pop up in practice a number of times where a body corporate has said, we really need to put something here, but that's exclusive use and we have no right to go and put it there. And I think that needs to be addressed. So if you're looking at putting something into somebody's common property that's exclusive use, go back to the design. We'll go back to the initial question of where am I going to put this? So after having gone through that decision-making process, you then pop down to this next, input, output box, which is title searches, encumbrances, and the development approval. This is again fundamental. You grab the title search of the common property, you grab the title search of the lot. Why? Because they'll have things like easements on them. They might have registered leases on them. And those things are relevant. The other thing that's relevant is the development approval. The development approval might contain conditions that are relevant to the installation of either the PV cells themselves or the rest of the infrastructure. If the titles are clear, you can move on and we'll come back to the design phase. But if the titles are not clear, you've got to have a look at those easements, those covenants, or those conditions. Now, easements, self-explanatory, they're on the title. You're always going to be able to spot them, and they will typically come with an easement plan so you can see which area is affected. When I talk about covenant here, I'm not talking about a developer's covenant. I'm talking about a registered covenant, which is given in favour, usually of a local authority. Vegetation covenants, environmental covenants are common in some places. That's the sort of covenant I'm talking about. And when I talk about conditions, I'm talking about conditions within a development approval. So what you do is you grab those title searches, all the encumbrances on the title, whether they're registered or they're not registered, you grab a copy of that development approval. And we all know, of course, that the developers are supposed to give the body corporate a copy of the development approval during that first EGM at establishment. So if you don't have one, and your developer's not around, go and get it. It's a fundamental recommendation that I make to all bodies corporate is you've got to have your development approval. Just because the development approval has been performed doesn't mean that it doesn't remain relevant. It's relevant. I ask for it from bodies corporate that I'm giving advice to all the time. I've got a pool issue going on at the moment and I need it for that one as well. So when you've got them, you have a look at the easement, you have a look at the covenant, you have a look at the conditions of the development approval, and you ask yourself the question, am I allowed to do this work? Is it consistent with those things? And if it's not, all the way back to that where question again. All right. If, however, you make it through the gate, you can then start doing some serious design work. And by this, I mean, you're maximizing, or not maximizing, you're optimizing your solar system. So this is based on our expected electricity needs. And if the rotten government is going to charge us to export power to the grid, we don't want to be exporting power. So we might want a battery, to soak up, but how big do the batteries need to be? Do we just put as many PV cells on the roof as possible and then have a bigger battery? All those design questions come into play. This is usually where people are talking seriously to their preferred supplier so that you can help get, so that you can get that advice. So by the end of this stage, you've got a pretty well designed system, and you've got a much better idea of exactly what the system looks like. So we've designed the system properly now, so we know exactly where it's going to go, and we go back and we check the location again. And the reason that we do this, of course, is that now we know we've got to run the conduit up the side of the building. We can check where the tidal boundary of that is. Is it going to be inside the lot again? Do we have to deal with that unreasonable interference question under our statutory easement? If so, go back and redesign. If, on the other hand, it's okay, we can move forward. So again, if it's on the lot, there's no unreasonable interference, we can move forward. If it's on the common property, we can go ahead and consider the next issue, which is those bylaws. Now, look, I'm going to talk about bylaws that regulate owner installations in more detail later on. What I want to talk about now is sort of more of the odd bods and sods type bylaws. I'll talk about the ban the banners stuff in about 20 minutes or so, 15 minutes or so. But when we're talking about bylaws here, we're really talking about, bylaws that might regulate the external appearance of a lot or the common property. It might talk about noise and all the rest of it. I mean, the body corporate's bound by its own bylaws too, and it needs to ensure that it's not breaching them because it's the body corporate's role to enforce them. So you need to go and have a look at those bylaws. It's also an opportunity because this little part of the diagram is very similar in all three flowcharts, and it gives me an opportunity, and it's a bit complicated there, so it gives me a chance to walk you through it. So with respect to the bylaws, we're having a read of them, and now that we've got our design and we know where everything's going to go, we're looking for bylaws that directly affect what we're doing. So it might be appearance of the common property, it might be appearance of a lot, it might be noise. We're also looking for things that indirectly affect what we're doing. So if somebody else has a positive right to do something or to enjoy their lot or the common property in a particular way, doing what we're doing might impact that right indirectly. So we have to have a pretty broad view when we're reading the bylaws. Once you've identified which bylaws are relevant, you can then, you ask yourself the question, are there any relevant bylaws or not? If there's no relevant bylaws, you can move into obtaining quotes. If there are relevant bylaws, you say, well, first question is it invalid? Now, a lot of people might raise an eyebrow at that one. Oh, our bylaws are valid. We've had them for 20 years. We've never had any problems with them. And I say, well, if you've had them for 20 years, odds are I can find an invalid one, and open challenge. I'll bet you a bottle of red wine of my choice. If you give me your CMS, I can find an invalid one. I haven't lost that bet yet. So, and it's stunning the number of people who still operate with standard bylaws that were recorded for them when they first established their scheme under the old Building Units and Group Titles Act, by the way. Anyway, moving on. You check to see whether those relevant bylaws are valid or invalid. And if you can address their impacts, you can move to obtain quotes. If you can't address their impacts, you've either got to go and change the bylaws special resolution. If there's special rights or privileges, you might be looking at a resolution without dissent. So if you can't address those impacts, you go back to designing again. So we've landed in that happy place of obtaining quotes. Now, bearing in mind, we're talking about the body corporate doing this stuff at the moment. So the usual prudential rules apply. Go and get yourself at least 2 quotes. The way that's usually done in practice that I see is that there's a preferred supplier who you work with. You end up getting the quote from them. You then put them in the fridge, which they love because they contact you every week. How's my quote going? While you're trying to get a quote from somebody else. And of course, at that stage, you realize just how little you know about the solar sector, because there's different types of cells, there's different manufacturers of cells, there's different brand names of cells, there's different efficiencies, all that sort of stuff. I'll let you in on a little secret. Actually, the number of manufacturers of cells is quite low. There's not as many as you think there are. Things are rebranded. Once you know who the manufacturer is, there are then also grades of quality. And if you can work out the grade of quality from the manufacturer, you can start to compare apples with apples. That takes a little bit of research. It does take a little bit of digging and talking to a couple of people, but you can get that info. So normally you'll be getting at least 2 quotes, particularly with the sort of spending. Even though it's coming down, I think to less than $1,000 a kilowatt, it keeps coming down and down and down. You still, for a body corporate installation, you still want 2 quotes. It's just a prudent thing to do. So from there, after you've got your quotes, you're drafting and submitting motions. Now, by all means, have a hack at these yourself, but I strongly recommend you always get your lawyer to cast their eye over them, because it's amazing what a difference a couple of words can make in your motions between being acceptable and enforceable and having a problem. Now, you'll see there that I've split the drafting of the motions down into sort of 4 types of motion. I don't favour these huge 2-page multi-banger motions that are a simple yes or no, because people find that really hard to come to grips with in my experience. I prefer sort of 4 motions that get you there, that are all contingent on each other. And my reasoning, I'll show you in a minute. If you start with spending, for a project like this, I like to have a spending motion that basically says that the body corporate authorise spending on the solar project of up to $30,000. That gives you your spending limit. You may or may not need a special levy motion at that stage, but you've authorised the spending. Then you move over to your contract, and your contract is actually the whole, we're going to authorise the work to be done by engaging this contractor to do it. So the first motion is just, we're going to authorise spending. I split those 2 motions apart because you might have a variation to your contract halfway through the works. And if you've combined them together and the authority to spend is the same as the authority to enter into the contract, you might have to go back and get another approval to spend the extra money. So I usually recommend that people authorise in their spending motion more money than they need. So it might be the highest contract price in a quote that you've got, plus a contingency. So if you've got a 20 grand quote and a 25 grand quote, you might take your spending motion as 25 grand plus 5 grand for a contingency, so 30 grand. So your spending motion might be, let's approve spending of up to $30,000. Then you can go and choose your contract, which is going to be a same issue motion. It used to be called motions with alternatives. Since the 1st of March, we now have same issue motions. I smile because I actually spoke to the members of the department when they were drafting the notes to the parliamentary draftsman, and quite a few of our suggestions made it in. Rodney Fuss, my colleague, and I debated this for a couple of days, and we're pretty happy because a lot of our suggestions made it in there. So you can blame me. If you don't understand them, you can blame me. I'm happy to take that on my shoulders. So same issue motion for your contracts. You then got this issue of entry. Entry is obviously that power of entry. under the Act. Just before I talk about that, one more thing I've got to talk about with respect to your contracts. I did mention that it was also the authority to go and do the work. We've got another major provision that's relevant, and that's section 186 of the module, of the standard module. And this is the one that allows the body corporate to make improvements to the common property. All right. So the body corporate has to go through the process of getting that authorization. Now, so far I've used the language of imagine this is going to a general meeting, and I think that's appropriate most of the time. It's actually mandated under section 186 if you're doing something, if your project is over the basic improvements limit, and the basic improvements limit is $300 multiplied by the number of lots in the scheme. And I find more often than not, a solar installation, a decent solar installation is over that limit. So you need an ordinary resolution anyway. So with your ordinary resolution, you can do one of those basically per annum, one of those per financial year. If you've already just upgraded the pool and you really want to go ahead and do the solar PV, you can do another authorization using a special resolution. It's a little check on body corporate spending. So that if you're going to go do these major improvements to the common property, if you're within the ordinary resolution range, which is $2,000 multiplied by the number of lots, it's an ordinary resolution only. But if you do that more than once per financial year, the second one is going to need a special resolution to get across the line. And of course, you can go to an adjudicator and get an order as well if you need to authorize the spending. So you'll note just with section 186, which is the body corporate's power to go and make the installation or approve the installation, there's no requirements in relation to aesthetic or other considerations. Theoretically, the body corporate could put something offensive and horrible on the common property if it wished to. And that's not regulated by that section. That section is really all about how much money are you spending. It doesn't go to anything else. How much money are you spending, and how in what space of time are you spending it? And as I say, in my experience, usually it's going to be an ordinary resolution or a special resolution. And bear in mind, you can't break it up into little tiny bits and say, I'm going to do this bit by committee resolution and that bit by committee resolution. It's subject to that whole project rule. So now I mentioned entry. Obviously, you need the power to go and enter somebody's lot if you need to go and put that wire or pipe or cable. And so that's the section 163 rules under the BCCM Act. You've got to give at least 7 days notice. It's a good time, I find, to actually do an approval for entry then and there, because you've got the quote timing, and I usually do a bracket of time for the installers, because before you have the meeting, you call them up again and say, look, if your quote's accepted, when can you start? Now, finally, the other motion there is export or sale. I put this in because you've got this system on the roof and maybe a battery to help sort of pass all the energy out. You're either going to use it just for the common property, or you're going to use it for the common property plus you're going to give it to the owners, or it's going to be common property and then export some back to the grid. Depending on your electricity provider, you may need to go and negotiate something with them on that. You might need to change providers. So that's where you pick up on that stuff that supports what you're doing with the solar installation. I know recently, having a look at my own building, we're looking at getting solar on the roof in my little 3-lot commercial scheme. We're probably going to change our provider so that we can export back what we don't need. We're going to sell our electricity to lot owners on a first in, first served basis. Common properties hooked up to it all the time. I'm actually about to do some exciting stuff with my neighbours, where I'm going to try and use a facility sharing agreement to export our excess power to an adjacent community title scheme behind the meter, which is going to be a lot of fun, because I think that is actually possible under the regulatory regime. All right, so we're almost through this first one. So we've talked about power of entry, export sale. So your motions pass or they don't. Now, you see here, I've just gone, if they don't pass, you go back and have another go. You can stop there if you wish to, but I assume that you're going to go back and have another go. I strongly recommend that unless, if your motions don't pass, given that your motions are normally ordinary resolution, if they don't pass, you just don't have the majority of lot owners on side, so don't push it. You need to go back to the drawing board and work out what the problem is. One of the reasons for breaking the motions down is that it helps you work out where the problem lies. Is it the amount of money? Is it the contractor? Is it that someone, doesn't want their units entered into because you're being too intrusive, or they don't like the electricity supplier? So by breaking the motions down, you can usually find out where the opposition lies. And it's not always about money, by the way. So if the motions pass, we move on. You engage your contractor. Make sure you've got your licensed contractor. You've checked their QBCC history. You know whether or not they've had any directions to rectify, that sort of stuff. You've done your due diligence on your contractor. It may be necessary to go and get building approvals, and obviously your contractor will usually handle that for you. You've got your notices and paperwork. That includes giving those entry notices to the lot owners and basically finishing off all the paperwork side of things, signing off on the export sale contracts, that sort of jazz. And if you're going to sell the electricity to lot owners, obviously you can supply that electricity to them, but we need to remember the Merrimack Heights decision in the Queensland Court of Appeal. If you're going to sell them that electricity, they have to agree for it to be sold to them, and they have to agree to pay for it. You can't just jam it at them and require them to pay. And once you're finished there, the works are finished and you're all done. So that's a body corporate installation. Now, hopefully we're going to have heaps of time for questions. And I'll move straight on into the next flow chart. And this one is a lot owner's installation. Now, I'll go a little bit quicker through this one because I think you've got the idea of the flow charts now, and we'll be able to sort of cruise through it. So we start back at the beginning. Now, please flip your mind from body corporate to lot owner. So this is a lot owner who says, I want to go and get a solar PV system for me. It's not for my neighbours. It's not for the body corporate. It's for me. And there may or may not be existing systems in the scheme, but it's all about going and working out how that lot owner should approach it. This is how I usually help lot owners to do it. Again, I start with the survey plans, the CMS, so I can work out where it's going to go. We answer that fundamental question of where. If it's going to go on the common property, or any bit of it's going to go on the common property, we go back into that exclusive use side of things. And if we're going into that exclusive use side of things, we actually go into the next flow chart. All right. So park that. What I'm talking about here is your sort of classic, lot in a standard format plan where they want to put it on their own roof because they own the roof, or there might be a lot in the building format plan scheme, and they want to put it, on a common roof is the next one, but if it's an exclusive use roof, it's this one. So, and bear in mind that depending on the system, the system that you're looking at installing, you might actually need to follow both flow charts. I tried to start to put them on the one and it just got way too complicated. So basically you break your system down and you might need to follow both. So if you're looking at putting part of it on the common property and it's exclusive use, so it's not exclusive use, you pop over to the next flow chart. If it's on the lot and exclusive use, it's this one. So you drop down to your title searches, your encumbrances and your development approval. Again, they're fundamental. A lot owner should be able to get that development approval from the body corporate records. So you go do your BCCM Form 12 search to go and get a copy of those. And again, if you've got clear title, you can move forward to design. If you don't have clear title, so you've got an easement, a registered covenant or a development approval condition, you've got to go through that exercise of, can I actually do this? And if you're not allowed, it's back to the where question. If you're at designing the system, you get your design done, check your location. Again, if it's common property, can you redesign? And that's, when I say common property, it's lot or exclusive use common property versus normal common property. if you can redesign, go back and do it. If you can't, move over to that other spreadsheet. So again, moving forward, as the installation is going to happen on a lot or exclusive use common property, you then move over to the bylaws. Now, the bylaws here, the community management statement for the scheme can include bylaws and an architectural and landscaping code. An architectural and landscaping code is usually an attachment to your community management statement. They can be quite short, but often they're quite long, because I don't know an architect ever who is able to be pithy in anything that they ever say. And usually it will all be about, you know, placemaking and being in sympathy with the local environment. And I do love what they do, but sometimes it's difficult the way they do it. So usually you'll have either a bylaw or an architectural landscaping code, or both. And this is where we start to talk about what's colloquially known as ban the banners. Before I do, I'll just take you to two relevant legislative provisions. So a community management statement under section 66 of the Body Corporate Community Management Act must not have in its architectural and landscaping code provisions that conflict or that have no force or effect under the Building Act Part 8A, and that's the ban the banners provision. So in the BCCM Act, it says you cannot have in your architectural and landscaping code these provisions that offend that ban the banners legislation. Similarly, in section 180 of the Body Corporate Community Management Act, it says under subsection 8 that a bylaw must not include a provision that has no force or effect under the Building Act Chapter 8A Part 2. So that's where the restrictions on this ban the banners stuff come from. Why is it called ban the banners? That's the name of the policy that was explained by the then state government to explain these provisions when they came in back in 2010. But those provisions are relevant because they're the ones that usually get used to attack the bylaw by a disgruntled owner when somebody says they can't install solar PV on a roof. So what are those ban the banners provisions and what do they say? Well, they're in Part 2, over in the Building Act 1975, basically section 246L onwards. They apply to class 1A and 2 buildings, so houses, standalone detached housing, plus class 2 buildings, which is your multi-unit residential long-term accommodation type buildings. They specifically apply to community management statements, including architectural and landscaping codes. And what do they do? Well, what they do is they neutralise bylaws or provisions in a code which have the effect of doing certain things. And one of the things that they neutralise is a provision that says you can't have solar PV. Wham! That provision is void in certain circumstances. What they also do is then say, if the provision is restricting where you can put solar PV, other than for good reasons, like the structure of the roof, then that restriction is read down, okay? So your first level restriction, or your first level, is a prohibition. You cannot have solar PV, and it's a prohibition. And that prohibition is there merely to enhance or preserve the external appearance of the building. That sort of prohibition used to be common in the old developers' covenants that you saw in residential land subdivisions. It found its way into architectural and landscaping codes, and so it was a bit of a pest. There has actually been a good Queensland Court of Appeal decision on that, because it's actually narrower than people think. But if the restriction is there for aesthetic reasons and not structural reasons, because the roof might not be able to hold all of those PV cells. So if it's there for a good reason, which is other than aesthetics, it'll be upheld. But if it's just aesthetics, then it can be knocked out. The second one I said was restriction. So this is about where can you put it. So if the restriction in terms of where can you put it, again, if it's there for aesthetic reasons and not for good reasons like the structure of the roof and how much weight it can take, because solar PV is in the same barrel as hot water systems. And if you have a rooftop hot water tank, obviously that's a fair bit of weight. And if you've got 20 people trying to put a hot water tank on one roof, you know, who knows the sort of structural integrity that you're going to need. So what these provisions do is that they neutralise bans, they neutralise restrictions on locations, and they also neutralise this consent issue. So if a bylaw requires that consent be given by a body corporate before you can do an installation, what it'll do is it means that consent can't be withheld in the context of solar PV if the reason that it's being withheld is purely, again, because of aesthetic reasons and not other reasonable reasons. Now, of course, the government was worried about that last one, because what they were worried about was, oh, that means that I'm a lot owner and I have a right to put a hot water system or a PV system on the roof. You can't stop me because you can't refuse consent. There's actually a provision in the sections there that specifically says this does not mean that lot owners have an absolute right to go ahead and do this, and they don't have a right to go ahead and do it where they're going to interfere with someone else's use and enjoyment of their lot. All right. So look, that's a really brief summary of those provisions. They are complicated, and that I only go through them quickly because they are. I'll give you a plug at this point for an article that I wrote a couple of years ago called Ban the Banners or Not, and that relates to that Queensland Court of Appeal decision in Betson Properties and Tyler. If you email me or contact Nikki, I can make a copy of that article available to you because it explains those provisions in a lot more detail and how they work in practice. So coming back to our flowchart, we've dealt with this ban the banners stuff. So this is where, you know, do you have a relevant bylaw? Thou shalt not install solar PV on the common property roof. Well, it's going to be invalid. So, you know, you've got a problem. If it's just because, you know, you shall not install because it makes the building look ugly, as opposed to you shall not install because we have structural problems with the roof. And so that's where this little section of the flowchart really starts to kick in. You know, do we have a relevant bylaw? Is it valid or not? Can we address the impact of it? And again, you then go through this process of obtaining quotes. This is the owner obtaining the quotes, drafting and submitting their motions. What motions are they going to submit? Well, at this point in time, what are they doing? They are putting in solar into their lot and into an exclusive use common property area. And so where that takes you is it's their lot. So typically, unless you've got a bylaw which is actually impacting their lot, they'll be okay in terms of not necessarily needing body corporate approval. Where it is an exclusive use area, however, that they're putting the installation into, then they need to go and have a look at section 193 of the Act. And what that basically does is it says that if the exclusive use bylaw authorises the owner to make the improvement, they can go ahead and make it. Otherwise, you know, if there's no authority in the bylaw to go and make the installation and the value of the installation is over $3,000, they're going to have to go get an ordinary resolution to approve it. What that means then is if the installation is under $3,000 and it's in an exclusive use area, they can just get a committee level approval. So this one here could well be, depending on the price of the system and where it's going, just a committee level approval. But if it's over $3,000, you know, you'll be up into that ordinary resolution range. So what we've then got is we've ticked off on installing the works. And of course, when I say consent to application here, if you need a building approval and the installation is going into an exclusive use area, the body corporate is the owner of the common property and the local council or the building certifier, more relevantly, might say, I need body corporate approval. And so that's where you get this little consent that might come from the body corporate. Now from there, the rest of it looks pretty familiar to what we did previously. The only sort of quirk that I'll give to you is two things. The first is that if they don't like the result, they can pop off under Chapter 6 of the Act and dispute it, all right? And the second thing is obviously in relation to if they're putting some stuff into their exclusive use area, and they're otherwise undertaking work, it's usually a good idea to let the body corporate know that that's happening before it starts happening. Otherwise, you inevitably get complaints. All right, now I'll trot through the last flowchart pretty quickly. And this is where the lot owner is putting the system on the common property and it's not exclusive use. So this might be, imagine, you know, a low-rise, 2-level villa complex with 2 lots per villa or 4 lots per villa. They're building format plan lots and they've each got their section of roof above them. Okay, that's that sort of classic scenario. So in that sort of classic scenario, the first question, I mean, all of this stuff we've done before. So if you're in the where of the lot and the exclusive use, go back to the last spreadsheet that I did, because this is really all about just it's on common property and it's not exclusive use. You go through the same system that we've done twice before, and where it all starts to happen is down at this, where it all starts to happen, my apologies, is just here at the easement right arrangement. Because what we're talking about here is a lot owner who wants to put a great big system up on the common property, and they're saying, I want to go ahead and do that. It's common property. I don't have exclusive use. Well, when you put a permanent improvement on the common property for the benefit of your lot, you need 2 approvals. The first is the approval to put it there, and the second approval is the approval to keep it there. And the authority for that is a Court of Appeal decision called Katsikalis. So in terms of the authority to put it there and to keep it there, there's a statutory easement right under section 115(0) of the Land Titles Act. And that's an easement in favour of the lot against the common property for putting in utility infrastructure to supply utility services. So it's the same sort of thing that we talked about for the body corporate before, and subject to the same limitations. So you've got this, what that easement allows you to do is to establish and maintain. So using the Katsikalis test, you might think, well, that means I just need the easement because establish means put it there. I actually tried that argument in front of an adjudicator back in 2015 and I lost. And the case is called Jansi, J-A-N-S-E-A, and it was about the installation of a lift for a disabled lady. And what the adjudicator said was, look, using the Katsikalis test, the Katsikalis principle, the easement right allows you to keep it there. It doesn't allow you to put it there. So that means you need a separate motion, a separate approval to put it there. So under what section are you allowed to put it there? It's section 187 of the standard module. And this is improvements to the common property by the owner of a lot. And basically you can go and make that improvement if it's on a committee level approval, unless it's not a minor improvement, $3,000 or less, it detracts from the appearance of the lot or the common property, or it's going to promote a breach of your duties as occupier. So it's going to cause you to breach an obligation to maintain or a bylaw or whatever. So if it complies with those 3 things, you can get a committee level approval. If it doesn't, then you need an ordinary resolution. And that's under section 187. So that's the, can I put it there? And then the easement allows you to keep it there, okay? So again, after you've been through that process, you're back down, you've done your design, you've done all this stuff. This is where you're really having a good close look at that ban the banners, those ban the banners provisions, because they're really going to apply to you here. Because you know, the body corporate might try and stop people from putting stuff on the roof or a proliferation of stuff on the roof using the bylaws to be able to do it. Now, the only other thing I'll say about this flow chart, and it's obviously very similar to the last one, is that down at, when we look at the motions, we've got that section 187 approval to install. You might need a consent from the body corporate in terms of the building approval again. And this is not, can I please exercise my rights under the easement? This is, I want you to acknowledge my easement right. I like to chuck that in there so that then there's an acknowledgement that the keeping it there is going to happen under the easement. And again, if the owner's not happy because there's a refusal, you can pop off and dispute the result. Otherwise, you follow through. And just one final point in relation to notices and paperwork. When you're using that statutory easement as a lot owner, you've got to comply with Section 68 of the Body Corporate and Community Management Act, which is exercise of rights under the statutory easement. And this is you going onto the common property and doing this work, your contractor. So you've got to give reasonable notice. You've got to comply with security and other arrangements ordinarily applying to persons who enter the lot. So that might be the workplace health and safety sign-on stuff. And of course, there's some exceptions to that based on emergencies. Now, I've covered those last two very quickly, and I did that because I want to make sure that you've got plenty of time for questions. I've got some questions here, but that's a lot of me talking. So I'm going to throw to Nikki. And Nikki, perhaps if you want to marshal some questions and we'll hit them.
Excellent. Thanks, Michael. Do you mind just unsharing your screen if you can? Thank you very much for that. They're wonderful. And as we said, we'll get those out to everyone this afternoon when we send the recording out with a few other links and bits and pieces in the email as well. So stand by for that. Yeah, we did have some questions come in, some really interesting ones. So if you like, I'll read through those one at a time and you can address them.
Sure. Just before I do, Nikki, for those people, I've taken a bit more time talking than I usually expect. So I'm happy to hang around as long as we've got questions that are coming in. So
excellent. That's great. Thank you so much. Okay, here's the first one now. Can the committee restrict how many solar panels we can put on the roof? At the moment, we're restricted to only 8, but there's room for a lot more.
So the committee can't do anything independently of itself unless that's actually set up under one of those provisions that I just spoke about. So if we're talking about a lot owner who wants to go and put solar PV on the roof, it's a minor improvement. It's not going to detract from appearance, and it's otherwise a committee decision. Then the committee might say no for another reason, for another valid reason. Where this sort of question usually indicates that there's a solar bylaw in place, because the body corporate has thought about it and they've said to make sure that there's a fair sharing of the roof space, and based on the amount of weight that the roof can take, everybody's limited to 8 cells of maximum size. All right. Now that would be a valid bylaw because it's not about aesthetic appearance only. It's about a fair sharing of the resource. And if it's the committee who's empowered to make a decision to approve under that bylaw, then that should be okay. And it's about then giving an approval pursuant to the bylaw, because the bylaw is structured in a way to make sure that it's fair and that there's no structural overloading of the roof. So that question is very much going to depend on where that's coming from. If it's under an existing bylaw, more than likely. If there's no existing bylaw, but it's a minor improvement, then it's a committee decision. So yeah, as long as they've got valid reasons for it, they may be able to.
So from a lot owner's point of view in that situation, would they approach the committee and then ask them what the reasoning for the bylaw was?
Yeah, I mean, I usually, when you do something like this, I like to leave a paper trail. So you get a report from an engineer, for example, or a solar company with an engineer, and you commission it. I mean, if the body corporate's attitude is, let's let people put their own systems in because we don't want to, right? We, the body corporate, don't want to, but let people put their own systems in. Get yourself a good solar company and or, an engineer, and then turn around and go, rightio guys, how do we do this fairly? And let's design a bylaw around that, and then have the report on the body corporate records to support the bylaw. So the reasoning is there. So if someone comes in later and says, I want 32 kilowatts and you can all go to hell, and I've got plenty of money and I'm going to take this all the way to the Court of Appeal, you can turn around and say, well, here's the reason that we did it the way that we did it.
Okay, excellent. Thank you. Now, we've just had one come in from Judy in the chat, so I'll read that one out. If all of the roof is taken up by one lot, does it mean that there should be an easement registered against the property, and should there be something in the bylaws as well?
Okay, so now this happens from time to time, and it's usually because someone's gotten in first, and I find it's really unfair. That lot owner has taken advantage of the easement in favour of the lot for establishing and maintaining utility infrastructure. So the keeping it there is covered by the easement. Now, there's a little quibble there in terms of a limitation on that easement right, because if you dig into that easement right, there's a restriction in relation to you know, the reasonable use and enjoyment by other people. And so there's a crack. I won't grab it out because I want to answer as many questions as possible, but there's a crack there where some light may be able to get in. That's the start of it. The second thing is that you still need the approval to put it there in the first place. So you go back and have a look at the approval and see what it says. If it says for this installation or on these terms and conditions, you'd be looking over that with a microscope. You know, are they in compliance with the conditions? Is there another crack there that we can pull apart? I think it's just horribly irresponsible that if it's a shared roof, that one person gets it all just because they're first in. And to me, that's a failure of governance by the body corporate to actually address that. So that's the sort of question where you really need to dig into that proviso in the statutory easement and how it's affecting other people. And you need to dig into the approval to find out whether or not there's some space to get in there and have a look. Because the other thing is, you know, PV cells are not forever. They have an effective lifespan. And if you're clever, you can get ahead of that, and you know, you put in place bylaws that actually will deal with the renewal. So if somebody then says, right, I've got the whole roof and I'm going to put new cells in, and there's a bylaw that says, well, you know, it's framed correctly so that it's prospective, you may well be able to catch that before it happens again.
And you mentioned the paper trail, and this is an instance where it's just so important for the decision-making process to be documented, isn't it?
Yeah, look, as with anything in bodies corporate, if you can't, you know, if you're not documenting it all, including from a committee and body corporate position to justify what they've done, you know, good legal advice will tell you, you just can't go and do the aesthetic stuff all the time. This is about, and I think that's a bit of an old view now. Most people are with it. You know, it's an Australian thing. We're big adopters, and anyone who's complaining about PV cells on the roof these days really needs to pull their head in, to be perfectly frank.
Okay, all right, well, we'll move on to another one. There are a number of initiatives being put forward to Strata regarding solar energy in New South Wales. Most appear to be generated by local councils. Is there similar available in Queensland? And if so, what and by whom? Are there any federal or state initiatives for solar to Strata in Queensland?
Look, unfortunately, I've got nothing on that question. I'm more than happy to say when I don't know the answer to a question, and I do not know the answer to that question. You know, bear in mind how many councils are there in Queensland. So this is one of these ones where it's just, sorry guys, hit Google, or if you don't like being watched with everything you do, hit DuckDuckGo, and go and do a bit of searching and find out. I'm sorry, I can't give you that answer. And this stuff changes all the time. Like I do work for a publicly listed electricity retailer, and you know, I'm getting the updates all the time. This is a moving policy space. You know, the government floats a thought bubble about charging people to feed solar back into the system. Why? They don't actually want to do it. They just want to slow down the rate of export installations and increase battery installations.
Okay, we might look into that. I'll see if I can get some information out to people about it. But I must admit, we get lots of information coming through from New South Wales, from councils, and we usually share it with our audience. But I don't really have anything either to add to that at this stage. So I'll see how I go. Thank you. Okay, we've got another one that's come in. I have purchased a unit off the plan. This is from Terry. Yet to build. Plans and marketing show solar installation post-build to be decided by Owners Corporation. Anything we should be aware of now to facilitate post-build install, or even better, any chance of doing install whilst doing the initial build?
Plans and marketing show solar installation post-build to be decided by Owners Corporation. Yeah, that's interesting. I mean, it's a really hard time. You know, there's a theory of groups that I like to refer to when it comes to bodies corporate that are freshly established. So it's forming, norming, storming, and mourning. And the idea is that you get together as a group of people, you form, you work out what your common values are, that's norming, and you come together as a group and start to understand each other. There's storming, okay, which is where you really start performing and doing well as a group. And then there's mourning, when the group breaks up. Now, when you're doing something like this, you're trying to get to the end of those first 3 stages really quickly, because you can do some pretty suboptimal things in that first 12 months after you come together as a group. In direct answer to the question, anything we should be aware of to facilitate post-build install, get that body corporate owner's role as soon as possible, get in touch with the owners, start talking about solar, start talking about options, have a look at the survey plan. Is there any areas of common property where we could put a battery, you know, or a set of batteries? Because that's really something you should be thinking about. It doesn't have to be the first stage, it might be a stage later. You might think about a progressive installation of solar as body corporate funds come in. So yeah, there's lots of things that you can do to be aware of. The biggest one is to get on the committee if you can, so you've got your finger on the pulse. Make sure you're getting copies of minutes from the body corporate manager of committee meetings and general meetings, and correspond with the body corporate committee. If you're not on it, hey guys, are we going to get solar? Can we talk about it? You know, we want to make sure that there's a good setup put in place and it's fair and equitable and everybody gets a good run out of it. Yeah, so there's plenty of things you can do.
Excellent. Sorry, I was just copying and pasting a question that came in there, but okay, so another one that we've had. I need to know if I can resist having common solar panels on my roof, as I'm the owner on the top floor unit where proposed panels are to be installed. There are already roofing problems elsewhere and have not been repaired. I don't wish to be a candidate for this down the road. Can I say no and have my wishes legally upheld?
Okay, so again, this is going to come down to, is that a common property roof or is it a lot owner's roof? Now, if it's the lot owner's roof, putting a great big solar PV array in, particularly where there's a history of structural problems or leaking, which is a common complaint with mobile phone towers, by the way, or little radio installations and satellite dishes. You know, you're going to get into that unreasonable interference territory pretty much straight away. If it's a common property roof, though, and it's like, I just don't want them there because there's a structural problem or there's been leaks, kind of 2 different problems. All right. The first one is get the body corporate to fix up the structural problems and the leaks. The second one, which is, you know, let's have a look at PV. I mean, if the first problem is disposed of, the second problem shouldn't be a problem. But if, unfortunately, and I've had to beat some bodies corporate over the head with a stick many times to actually get them to understand that it is their job to properly maintain common property, whether they have the money or not, right? Because some of them adopt a business mindset. You know, they do the whole risk management calculus. You know, what's the risk of letting us go for another couple of years while we get the money, or just padding it off, and then we'll use our body corporate insurance to go and defend a legitimate claim of leaks just because we don't have the money because these are investment units. You know, that sort of, it absolutely drives me wild. But anyway, if the issues have to be brought together, a really good approach for that lot owner is to commission an independent report about the leaks, about the structural issue, and then which anticipates a solar installation. So that then if a decision is being made by the body corporate to go and do the installation, again, the body corporate needs to make a decision to actually go and do the installation. Then you've got really good grounds to go to the adjudicator's office and say no. And the reason the no is, I did this report, I gave it to the body corporate, I told them what the issues were. There's a trailing issue in relation to structural problems and water leaks. This is going to make it worse. That's not my opinion. That's the opinion of this expert. Let's knock that over. And in fact, I like a good counterattack in that situation. The body corporate needs to actually go and maintain the roof space first. And then if they should be spending money on that rather than spending money on this PV because my roof leaks.
Okay, great. All right, we've got another one to do with a duplex. So there's an owner in a 2-lot community title system of 2 duplexes sharing a common connecting wall. The other lot owner has 2 members forming the body corporate committee. I'm not on the body corporate committee. The other lot upgraded their solar panels on their roof, but the new system has encroached over my roof by 1 metre. They did not ask any permission from me or even advise me that they were going to have the work done, which would have cost approximately $4,000. If the roof over both lots is common property, what are my rights to ask the other lot owner to vary the solar panel arrangement so it doesn't come into my lot roof area?
Yeah, so strata lawyers typically have a rule: the smaller the scheme, the bigger the problem. And I have a personal rule, which is there's always one. So in any strata scheme, there's always one tinfoil hat wearing wingnut who doesn't like 4G towers, or who believes that COVID-19 is a global conspiracy. So when you're in a duplex and there's always one, it's always the other person because it's never you. So in that sort of situation, the best recommendation I can say is lawyer up, but don't go firing off a World War III letter. I'm handling a couple of duplex disputes at the moment, but the way I try and handle them is I say lawyer up, but then every communication is through the lot owner and gentle, and it's about addressing the problem, not the person, and it's about real issues and not minor issues. So in this situation, I just turn it around. If it's if it's common property, there can be no encroachment, all right, because it's common property. Whereas if the encroachment idea is, well, it's my roof and I should be able to use the whole space, that's a different concept. And that's about, well, I want to put a system up and you're using more than your fair share. So that's a different question. Taking up all the common property or taking up a large area of common property without approval is what's called ouster, which is an old legal doctrine that's been around for like 1,000 years in common law. It's unlawful, you're not allowed to do it. But there's multiple angles of attack there. An absence of a decision to enable it to occur. Two people being on the committee and not that lot owner, that's ridiculous. And in fact, I have to go check the provisions. It might even be unlawful or improper. And it just begs for a finding of fraud on a minority, in that situation. So yeah, there's multiple angles of attack. But really, at the end of the day, the fundamental question is it causing that lot owner a problem? Are they wanting to put up a system using that space? Because if it's not, I can put on my I'm now a competitor to Stratum Legal hat and go, oh, that's terrible. Let's go and sue them and give me $20,000 and I'll beat them up for you in court. But I'll put on my Stratum Legal hat and say, are you wanting to use that roof space for your own system? Because if you're not, why have that fight?
Okay. All right, the next one, I have the solar panels above my top floor apartment in Brisbane. Approval was given by the body corporate with the proviso that the panels get inspected regularly, but no actual time frame was listed. I've now been asked to have the panels inspected every year, but I can't find any Queensland legislation that makes it mandatory to do so. I've checked twice with our Strata insurance company and they say that regular inspection is okay around every 3 years, as long as there are not any obvious problems like leaf blockages, etc., which we don't have. Our roof gets an annual safety inspection and certification, and the solar panels are automatically checked out as part of that, which includes anchor points. Do I now need also to get my own inspection every year at the request of the committee?
Yeah, that's a beauty. Going back to that approval. So at the end of the day, an approval is a privilege, it's not a right. And so treat it like a privilege. Having it up there, even though you spent the money, treat it like a privilege. In the absence of standards, talk to an expert is what I usually do. So even if that's like a plumber is an expert. My old man was a plumber before he became a health surveyor. So, a solar installer can be an expert as well. An electrical engineer can be an expert. I know that, for example, you should be cleaning panels annually because it impacts upon their efficiency. And that varies based on where you are and whether or not you're going to get salt or dust or all the other stuff. So I'd probably start there. And then if it was, for example, annually, which I think is, kind of feels right, and that's just a feeling, it's not based on any legal principle, then, what do? There's solar companies out there that will come in and do a check, a safety check and a clean, and get a little bit of correspondence from them and flick it through to the committee. you know, and I like to get ahead of that stuff. Like before it becomes a problem, establish a course of conduct. You know, 7 years down the track, someone on the committee says, you know, that shouldn't be there, you know, it's an eyesore, rah, rah, rah. And you've got 7 years of history of doing that. And then they turn around and say, oh, you know, I found in the conditions they're going to inspect regularly. It should be done once every quarter, for example. Well, you've got 7 years of history of doing it your way. And then all of a sudden some idiot is saying it's got to be done quarterly. Well, justify that. You know, I've got my justification. Where's yours?
Okay, we've got one here. What are the regulations for solar heating for pools?
What are the regulations for solar heating for pools? Ye gods. Yeah, that's a bit out of left field. Right. So if we're talking passive solar heating for swimming pools, that's not solar PV. And I don't think that it's going to qualify as a hot water system under the Building Act. It might. I don't have that answer off the top of my head. But if it qualifies as a hot water system under the Building Act, then you're going to have the same sort of approach for the banners as we talked about before. I keep reaching for the provisions. It's one of the challenges of my job is that there's like 1,500 pages of legislation or more. But if it doesn't fall into that, then you're really just talking about a bog standard installation of a thing on common property. Usually that thing is going to be for a common property pool. If it's for a private pool and you're putting it onto common property to heat a private pool, then you're in the same space as making an improvement to the common property for the benefit of a lot, which brings us into the Katsokalis principle again, which means authority to put it there, authority to keep it there. Now, the real problem with that is the authority to put it there might be an ordinary resolution at a general meeting, but the authority to keep it there becomes a real problem, because if you don't have an easement, you're going to need a transfer of the land, a grant of exclusive use, a lease or a license. And most of that stuff is going to be resolution without dissent. And at the lowest, you're talking about a special resolution, depending on the regulation module. So yeah, if I got that question, the first place I'd look is, does it qualify as a hot water system under the ban the banners legislation? And if it does, you know, let's go there, because that's going to give me potentially a right to keep it there. Just one thing, in relation to the lease, license or transfer, there's the issue of, is it utility infrastructure? There is an argument that it would be utility infrastructure for the benefit of the lot, and because the utility service that it's providing is hot water to the pool or warmed water to the pool. And if it's warmed water to the pool, that means that the passive solar blanket on the roof would be regarded as utility infrastructure. So you may be able to get into those statutory easement rights, which then means you just need approval to put it there, and then you've got the easement to enable you to keep it there. So yeah, I'd look at that.
Okay. I think this is an interesting one. What controls do body corporate have regarding the type, size and power of systems installed on individual villas?
Type, size and power of systems. Oh, yeah, okay. I've got an equally interesting answer to that one. There is a provision, I can't remember the number off the top of my head, but it's about, this is in the Body Corp Community Management Act, and that is about interfering with utility services. So there's a general provision that says you shall not cause a nuisance or an unreasonable interference with another person's lot. There's another section very close by it that says you shall not interfere with the utility services or the utility infrastructure. Now, if you go overloading the system by virtue of the fact that you've got this horse of a solar PV system on your roof and you're causing systemic problems outside of your lot, that will probably get caught by that. And that's an offence provision from memory, so you can get prosecuted for it. But of course, the obvious answer, the less fun answer, is that you can put in place a bylaw that regulates the use and enjoyment of the lot. So that's where you might be able to turn around and say, look, we've had an electrical engineer look at everything, you know, for safety, because these things generate big voltages, you know, big voltages, depending on how they're put together. And that can, it's not unusual to get fires starting in bad installations or poor installations with poor insulation in various places. So for safety reasons and for reasons of electrical engineering of the infrastructure, you could put it in a bylaw that actually spoke to that. You can have any system you like as long as, it doesn't generate more than this many kilovolts, or, and put some reasons in. And the reasons will be, this is not to do with aesthetics, it's reasons to do with the electrical system set up in the scheme and safety. And I don't, that's a valid bylaw. If you draft it properly, it's a valid bylaw all day long.
Okay, we've gone over quite a bit, so we might just have one more before we finish up. So for the last one, if there is a 2 or 3 story building, there is not going to be enough roof space for all parties. Is it then going to have to be a first in, first serve?
No. And this is where it comes down to passive body corporates and active bodies corporate. I mean, years ago, I wrote an article about this with a view to trying to get a bit of work from bodies corporate about drafting bylaws that were fair to ensure a fair allocation. And I think I've got it kicking around on the system somewhere. As per usual, anything proactive is a hard sell, because most of the time it's just we're all busy people, and it's not until we have a problem in front of us that we actually really have to come and address it. So short answer to that question is no. All right. Long answer is, to avoid it becoming first in, best dressed, get active, get on the committee and run an agenda of let's put a solar bylaw in place, or go and do some research and find one, put it forward to the committee and say, this shouldn't be first in, best dressed. It should be, either the body corporate will do it and take responsibility for it, right, and take the benefits of it. And there's really interesting ways of doing that. I mean, what I'm researching, my own community title scheme is a bit of a test bed for me. One of the things I'm looking at is we're going to loan money for the body corporate to buy the system, to put it on the roof, to supply the common property, to sell it to the lot owners on a first in, best dress basis, but we're going to charge it at the retail rate less a percentage, which is more than the repayments on the loan. So the loan gets repaid. So we're getting a little bit of a discount on our power because it's all commercial lots. That will help repay, right? When we get to the end of the repayment period, it's a body corporate asset. And so then, we still sell the electricity. The idea won't be to make a profit, and I'll have to fine tune that, but we might make some improvements like putting some battery storage in and those sort of things. By that stage, we'll probably have electric cars downstairs that are being charged. So yeah, it's get proactive, preferably get on the committee, get the issue in front of people, because it will either be body corporate buys it and puts it in, or body corporate sets up the framework so that people can then do their own, or it's going to be the Wild West. All right, first in, best dressed, I'm a cattle baron and this is my land and you can go to hell, or here's a fair system that you can all work within, or body corporate's going to do it all. Just while we've been talking, I had a quick look back at that solar heating question. Solar hot water system includes any part of a water heating system designed to heat water using light or heat from the sun. So you may well be able to use the ban the banners provisions for the pool heating, which is kind of a weird result. It's something I learnt today, which is good.
Excellent. I didn't think that was such an interesting question, but it's turned out to be very interesting. Okay. All right. Thank you so much. We've got a few questions that we didn't actually get time to get to, but if that's okay with you, Michael, I might send them through and we'll get those back to people or publish them up onto the site anyway. There's just a couple that are outstanding.
Sure.
Okay, that would be great. Thank you so much. So before we go, I'd just like to say a really big thank you to you for all of the time. The flowcharts were wonderful, lots and lots of really detailed information in there, and for spending the time with us to answer the questions that came up. Now, we mentioned at the beginning of the session, you had some information for us about the Strata legislation. So everyone that's still hanging around.
Look, there's really big movements in this space going to happen over the next 2 years. At the sort of outside edge, within the next 12 months, we're probably going to see a fundamental change to the way we disclose information to people when we buy and sell. That'll be like a fundamental change. And then we may even see some scheme termination rules in that time frame as well. At the moment, if you're trying to terminate a scheme so it can be redeveloped, because the scheme might be in a knockdown type condition, but you've got one person that's been living there since the 60s and they're just not going to move. You know, retired war widow is a classic example, and they're blocking the whole thing. We are likely to see some provisions in the next 12 months that will address that fairly. And that's a really big deal because we've got a lot of stock, particularly on the Gold Coast and in Brisbane, where there's older community title schemes that really are getting to the end of their built lifespan, not just their economic lifespan, but their built lifespan. Because under our Act, our buildings are immortal. We have to continue to maintain them in a good condition all the time, whereas it just gets to a point where the cost of doing that is ridiculous.
Wonderful. That's really, really great information, and it's huge information. So thank you for sharing that with us. That sounds fantastic. Really, really keen to hear more about that as it comes about. So thank you very much to everyone that joined us today. Thank you again to Michael for spending the time with us. And yeah, keep an eye out for the email coming this afternoon, and also for other regular webinars that we hold on. We should be doing them on a fortnightly basis. So thank you very much. And yeah, we'll see you next time.
Thanks, everybody. I hope you got good value out of it.